Is Holt still?
Ladies and gentlemen, we are live.
I was gonna take my granddaughter riding. I didn't know. Hi, everybody. Hey, everybody. The track was still out there. Oh, who's going? Hey.
Hey.
How are you?
Great, how are you? How are you, man?
Good, and yourself?
Good. That's pretty good. 40 tractors on Lagones. Hope sold it to somebody and then they sold it to somebody else. They sold it.
We just need some action.
Yeah.
You've come to the right place.
So then Doug said, they need to put that pivot there.
Right.
I got a really good on my Facebook. It's on my Facebook page. Right down at the bottom, there's a really good deal on Hope. All the records that he set in Ranger running.
Really?
Yeah, because I don't think I can control it.
My mom used to just get the biggest kick out of you. Talk about opposites that attracted City Harbor is kind of just and Holt kind of crazy.
And if the years with that swap.
Right, right. Thank you.
The gal that lives out there, her little house is where we get the whole. She's a blonde girl that works at the car wash in Sunnyside. Same spot.
Okay.
All skinny. She's worked there forever. She lives, her husband lives there. Best renters ever, but.
I'm gonna go
Take care of the yard and things up. Nobody lives there. Nobody lives there at all.
I was tempted to stop there because I did my nails in Grammy today.
Oh, you good?
Yeah.
Still got rights on the lake.
Okay, we're not on yet.
Parts of that lake, yeah.
Okay, there we go.
I thought they had a bunch of doctors up there.
We're gonna go ahead and call this meeting to order, council study session, Tuesday, May 24th, 2022 at 6 p.m. So we don't have any old business. This evening, we're going to go ahead and move on to new business. We have WCIA Council's Do's and Don'ts presentation presented to us by Rob Roscoe from WCIA. So welcome.
Thank you, Mayor. As I said, my name is Rob Roscoe. I am the Deputy Director of Washington City's Insurance Authority. And I have a little bit of a presentation that I think we'll try and get up here shortly.
Rob, do you want to turn on your microphone? Just press the button.
Is that on?
Yes.
Okay.
Thank you.
And I probably need to stand here then, so you'll have to remind me, Sylvia, because I
No, that's
kind
okay.
of
You
get
don't.
a little antsy and I walk around.
No, that's fine.
Bear with me. A little bit of background. I've been involved with WCIA, we're Washington City's Insurance Authority. This is my second time back at WCIA. I've been there for the last 4 years, but I've been involved with WCIA for the last 22 years. Prior to this, I used to work for a member of WCIA, City of Auburn, so I'm very familiar with municipalities. I was a director at the City of Auburn in Human Resources and Risk Management. And prior to that, I worked at WCIA from 2000 to 2005. And prior to that, I also worked for a number of different insurance companies. So I have a very diverse background, but I'm very familiar with how cities operate and municipal exposures, because again, I've been involved with it for the past 22 years now myself. I'd like to say I'm closer to retirement. Either way though, next slide. WCA, we are a municipal organization. We are not a traditional insurance company. So we were formed via an interlocal agreement back in 1981. And we currently have over 166 different members throughout the state of Washington. So I go all over the state. I do a number of different trainings for councils. It's called do's and don'ts, but it's really kind of a best practices risk management advice. So if you have any questions, please feel free. This is why I am here. You do not want me talking for the next hour about insurance. I'm not that interesting, nor is insurance. So please, if you have any questions regarding what we do and how we operate, that's what I'm here for. As well as your roles as council and elected officials and the exposure present with what you do. Again, WCA, we provide $20 million in liability coverage for our cities, which Mapton is one. So you have $20 million in liability coverage with us. I should say, WCA, we have over $181 million in assets. We are by far the largest risk pool in the state of Washington. There's two other municipal risk pools that provide similar services as WCIA. But we've been around the longest, and we provide the most extensive coverage and most comprehensive coverage as well. Next slide. As I mentioned, we provide a lot of different coverages, actually. Primarily, and first and foremost, is liability. Liability is for claims filed against the city. That's where WCA comes in, and we provide liability coverage up to $20 million for that. Right now, we are in the middle of a it's called a hard insurance market, especially for government agencies, in particular, Washington and California. Insurance is very expensive because of lawsuits and lack of what we call tort caps. We do not have any caps in our state. So that means when there's a verdict, it could go upwards of, actually there was a $66 million settlement with the city of Seattle. That's a lot of money. So that's why it's very difficult right now for public agencies to find insurance coverage, because insurances basically don't want to underwrite government agencies. But that's why WCA exists. We were founded back in 1981 because of that reason. The old adage, you can't fight City Hall. Well, someone found a way to fight City Hall and someone found a way to win. So because of that, municipalities were left with very little options for insurance. So they decided to create their own company. And that's where WCA came into existence. So again, we provide that coverage for our members. And the nice thing about that is, we're a government agency. So if we ever have any money left over at the end of the year, that money goes back into our fund to help reduce future rates. So it's not going for profit to a company like most insurance companies are, which, don't get me wrong, we're a capitalist society and we're all for making money, but for government, that's not our role. Our role is to try and provide services and reduce rates for our members. We also provide both property and auto physical damage coverage for the city. So property is the assets that you guys own. Overall, I have close to $13 billion that we're insuring throughout the state of Washington. So Mapton's just one part of that, but we also provide auto physical damage. So if your vehicles are damaged and they need to get repaired, that's where WCA comes in. So we provide that physical damage coverage. Those are the programs that we underwrite and charge directly to our members. Then we also purchase additional coverages for our members that you select to purchase, such as crime and fidelity, cyber, and pollution premises liability. Now, the crime and fidelity is a separate pass-through program that you pay, and that's to cover if there's any type of theft, internal theft of securities or monies that were to be lost or stolen or embezzled. That's where that would come into play. We don't underwrite that and we don't charge it, but we get the luxury of purchasing it through 166 different members, so we get reduced rates for our members because of our buying power. We also provide in-house insurance services. So we have adjusters and we have risk management reps. Risk management reps primarily work with staff to help them identify and reduce the exposures present with what they're operating and what they're doing, especially with police, public works, sewer, water operations. Believe it or not, there's a lot of exposure out there with what they do. So our job is to try to educate staff as to how to eliminate or reduce those damaging impacts of third-party claims. So that's what WCI was created, and that's primarily what we exist for, is to provide those services for our members. So what I want to talk, next slide, today about is kind of city council and how council can kind of avoid liability, because you yourself can be a target for litigation. Probably didn't realize that when you decided to run for office, but congratulations, you're now elected. And I should say thank you, because I do know the time and commitment it takes to, one, be an elected official and run for a public office. And it is pretty much a thankless task sometimes. So I do appreciate your service and thank you for your time. And I do know how much it takes, because again, I used to work for a municipality and have to go to city council meetings all the time and all the study sessions that go along with it. But I should mention, for the most part, as a legislative body, you have some good immunities when you're acting as a legislative body. Doesn't mean that extends when you're acting as an individual. So there's, when you're adopting your budgets and your ordinances, your city codes, and your resolutions. That's primarily your role as that city council, is the legislative branch of the government. You don't want to cross over into the executive's branch, because that's when you start mixing duties and responsibilities. And while you're adopting those budgets and acting in a legislative capacity, you have good immunities as a legislative body. Once you start acting as an individual and signing your name without council consent, that's when you start opening the door to potential litigation or target to litigation from third parties. So be very careful about how you represent. You don't want to act as an individual, but as a council as a whole. That makes sense. Next slide. I do want to talk about land use because this is one of our biggest exposures, and this is a role you may serve on as a legislative body. And it can be very different, because now you're not acting as a legislative body, but you start acting as a judge or a quasi-judicial capacity, where you have to make rules and you have to make a ruling based on the evidence that's put forth in front of you. And this is where things can get very difficult, because you have to be fair and impartial. And there's a appearance of fairness doctrine, which basically says if a third party were to look at your ruling based on the facts and the records that were presented, they can draw a logical conclusion as to how you came to that determination. And you don't want your own personal biases or opinions impacting those decisions. And that can be hard sometimes, because one, you're an elected official and you sometimes have a platform that you want to run on. Maybe it's no growth, and you don't want growth in downtown area, you want to prevent something. Well, if your code allows for it, and now you're going contrary to that code and you're acting outside of the evidence put before you, you're creating a huge exposure for the city. And you have to remember what role you're serving on. And this is tough. When I was at the city of Auburn, my council was doing the same thing. They were making land use decisions. We eliminated it. We went to a hearing examiner form, so that way it would go directly to a hearing examiner, and then they could appeal it to Superior Court. Because we want to remove council, because that way you can talk to your constituents more. And this is tough, because you're only supposed to rule on the record before you. And as you know, there are public comments, and sometimes when you have an issue on the agenda, the public's going to come in and they're going to speak on that. But that public comment is not part of the record. That all it is public comment. You're not supposed to take that into consideration when you're making a ruling. It's just public comment. You can only take into consideration as to what's in the record before you. And if you allow that to influence you, that's where you can then get into some trouble. And you have to make findings of fact and avoid what's called arbitrary and capricious decisions, i.e. there's no basis or rationale as to how you drew to that conclusion. And once you go down that road, it's very difficult to get back. And it limits you. And it limits your interactions with your constituents. So just very careful about that. I do encourage, and WCA is a strong advocate for the use of hearing examiners just for that reason alone. So we've had some pretty significant litigation that arose out of council's actions. For example, and again, I've been around for 22 years dealing with public exposures. I don't like to call them war stories or more learning experiences, but we have had a lot of claims of litigation that arise out of these arenas. Next slide. Westmark versus City of Burien. This is a old claim. It came about once City of Burien was part of King County. It's still in King County, but when they newly incorporated, you had a development that was going into play for multi-family housing in an area that was going to block some views, in particular some council member views of the Puget Sound area, or Puget Sound. So council wasn't too happy with this development. It was vested under King County ordinances and rules at the time. Vesting means they had a completed and accepted permit that was in place. Vesting is very strong in Washington State. That once you have a property interest and you're vested, you don't want to change the rules on a developer because that's an unfair way for them to operate. So you can change laws after the fact, but they're vested, which means they operate under the rules at the time the permit was submitted. So even if you change the law afterwards, they still operate under the law in which they submitted their application under. So in Westmark, they had their completed permit and they did their development, but council found that they were trying to delay and stop this from happening because it was impacting their views. So they were acting in an individual capacity. And the record showed that they were making needless delays. And the court found that they were doing what's called tortious interference with the business expectancy. Well, we took that to trial and we lost to the tune of $10 million. So that's where these things can be very expensive that the WCA had to pay. And actually there were 3 different lawsuits, Westmark 1, 2, and 3. Westmark 1, we won part, lost part. Westmark 2, and long story short, it found that council was acting inappropriately because of those delays, because they had that internal interest in preventing that development from taking place. Mission Springs versus City of Spokane is also a big case. In this situation, you had a development going on where you had a mayor of Spokane, didn't want the development to happen, told his building official to deny the permit. Building official said, Mayor, I can't do that. There's no justification for it. Well, building official reports to ultimately the mayor. Mayor's strong mayor form of government, the mayor's executive branch, so they handle personnel decisions. Building official went to the city attorney, got the city attorney involved. City attorney advised the mayor, Mayor, there's no rational basis for us to deny this. We cannot deny it. Well, mayor said, I'm elected. This was my platform. I'm stopping it. Well, long story short, the city got sued. There was no legislative immunity because the mayor was acting outside of their capacity when they were directing the city officials to deny a permit that they had no valid basis for doing. So that's where it can be very complicated. And if you have concerns about that, talk to your city attorney. Call WCA. This is what we're here for, is to help you navigate those rules and those regulations so you don't end up into court in an awkward situation that could cost taxpayer dollars and monies. Now, that's not to say you can't win. There's another case, Woodsview versus Kitsap County. Here, you had a developer submit their application and staff has to review it. Now, if you talk to developers, they'll always tell you that staff doesn't know what they're doing. They take too long in the review process. You talk to staff says the developer wants us to engineer their design. They want us to redo it all because it's never complete and it's never accurate. So they're relying upon staff to make those changes for them. So it's a competing battle back and forth. Trust me, I've seen it, I know it firsthand. Now, in this situation, you had a developer that was very unhappy with the delays that was being caused and said that staff was taking unnecessarily too long. So he sued. Kitsap County went to court and showed, and they had a good record of what was taking place, saying, look, here's what happened. You had to go do X, Y, and Z. The developer did A, B, and C instead of X, Y, and Z, so we returned it back to them and needed him to come back. Once he came back, we reviewed it, and it ultimately was processed. There, the court found that the county acted appropriately. So again, you can win these cases. You just got to make sure you're following it and you're establishing a record of your actions and your conduct. That's where staff comes into play with records and making sure that they have accurate records regarding what takes place. Next slide. Personnel. I was a HR director for 12 years. Personnel is near and dear to my heart. Anyone tells you they know everything about personnel law, they're lying. It's impossible. It is too complicated and it's very dynamic because courts make decisions on a weekly and monthly basis. Those decisions can change the way we interpret laws. So what's legal today may be illegal tomorrow from a personnel employment perspective. So it's very dynamic and it's always evolving and always changing, and you have to be careful about collective bargaining agreements, protected class statuses. All these things are designed to protect employees. My plea for city council is you have a mayor. That mayor is the executive branch. That mayor serves as the executive board's staff. They're in charge of staff, not council. You want to try to avoid inserting yourself into that role because that's where things can go sideways very, very quickly. So stay in that legislative role. You're designed to set policy, enact ordinances and resolutions, not deal with the day-to-day operations with staff. And it can put staff in a very awkward position. I saw that firsthand where I had elected officials that wanted to talk to staff and give counter directives than what the mayor was giving. And staff can't win in those scenarios because, again, they want to please elected officials. They don't want to go counter to what the mayor's telling them because ultimately the mayor's the boss. So please try to avoid inserting yourself in that role because it can get very complicated and very messy very quickly. I should know, actually, when I was at the city, I got sued individually by an elected official. It ultimately got dismissed, but I was just doing my job as an HR director, trying to inform the elected official about those roles and those responsibilities. And long story short, it got dismissed and thrown out, but that's where things can get very complicated very quickly. And you can be held personally liable. And that's something that I can't stress enough for your actions and your conduct. Personnel law gets very tricky very quickly. Next slide. Especially with your own conduct, and your words carry weight. You're the elected official. Staff wants to assist and help you, but you have to be cognizant as to how you're treating them. You do not want to be derogatory. You want to be professional. You do not want to get personal. You do not want to talk about age, race, religion, what we call the protected classes. Those are all designed to protect employees, and if they feel like they're being treated differently based upon those protected classes, they could potentially have a cause of action. So that doesn't mean you can't say good morning, have a nice day, and be professional. But you don't want to start crossing into those other lines because once you do that, that's when you can get into trouble and get into litigation. I've seen it where it's very innocuous. I had a situation where a mayor was saying, you look nice today, Joan, or see you girls later. Kept referring to as girls and his ladies. Well, that's getting into gender biasness. And you don't want to be separating out that gender. That doesn't mean you can't say you look nice or I like your outfit, but you have to be careful because what's important is not your intent. I'm not trying to be offensive. I just am. But no, it's not that your intent is not to be offensive. It's how it's interpreted by those that are impacted by it. So again, if you're told to please refrain, especially if the mayor talks to you and says staff has concerns about your attitude or about your tone or about your speech, take that to heart and try not to argue, but just try to stop that behavior, because that's where you can then get yourself into future problems. Also, you are an agent for the city. If you witness inappropriate behavior, you should bring that to the mayor's attention so that the mayor can take action to stop that behavior from reoccurring. Again, it's not on you to make the behavior stop per se. You can if it's appropriate, but for the most part, it probably isn't, and we're going to ask you to please direct your attention to the mayor so she's aware of it, so she can address staff accordingly. Because again, that's her role as the executive of the city of Mapton. Next slide. Negligent misrepresentation. This can come up a lot, especially when you're out in public. You're at the supermarket and someone comes up and talks to you and they want to talk about city business. Be very careful about what you say, especially out in public. We had one situation. There's a town that has certain downtown ordinances that they had to have particular siding on buildings. Business owner wanted to re-side his building. Talks to the mayor while the mayor's shopping. Mayor, is it okay if I put on, I don't know, hardy plank, whatever it was? Sounds good, Joe, go ahead and do it. Mayor didn't know what the code was saying per se. So Joe puts it, starts re-siding his building. Code enforcement goes out there and red tags him because it didn't meet the downtown ordinance as to what needed to be on the building. I think Joe was a little upset. Yeah, the mayor told him he could do it. So he bought all this siding and hired a contractor to re-side his business. And now city code enforcement red tagged him, told him to stop work, and now he has all these damages as a result. So Joe ends up suing the city. I get the facts, I look at it and find out, Mayor, did you tell Joe he could side his building? Yeah, Rob, I probably did. Well, Mayor, then that's a problem. Because Joe had a detrimental reliance on you telling him he can go ahead and do that. You are the city of X, Y, and Z. I'm not going to name names, but you were the city. And Joe relied upon that to his detriment, so he has a cause of action now that I have to pay his damages for. So that's not what I'm going to try and fight and dispute. It's just a matter of how much do we actually owe Joe for what he's out due to his costs related to violating the downtown ordinance. Now, he did ultimately have to re-cite it per the ordinance because that's what held true. It's not that he could violate that ordinance now, it's just more he has damages as a result of Joe's misrepresentation to it. So be very careful about that. You don't want to take things into your own hands. If you're unsure about something, direct them to staff. Say, you know what, you should talk to the Public Works Department, or you should talk to our chief of police. I don't know if that's a criminal code. You should probably talk to the chief about that, or talk to someone in the police department, rather than make a representation yourself regarding it. Next slide. Defamation as well. Be very careful, especially in public. Everything we do, you're a public official. You probably know by now everything you say and do for the city is a potential public record. Be very careful about how you conduct yourself and how you refer to third parties. Okay, you can do a general statement, but you don't want to get into specifics and name individuals, especially if there's a code enforcement action going on about somebody. You can refer to in general what you want to do for the city, but don't start singling out people, because that's when you start crossing potential lines in areas that could lead to some potential litigation. Now, the truth is always a good defense for defamation, but again, try and be cognizant and aware of those situations before. Again, when you're talking, are you talking as a public official? Are you talking to staff, or are you talking to individuals? Know your audience. Know who you're dealing with. If you're talking to other public officials, be careful about that as well, especially if you have a quorum and Open Public Meetings Acts. WCA doesn't cover that, but that is something that you need to be aware of. We see it a lot, especially with emails and email correspondence that can go back and forth, where maybe there's a meeting notice that gets sent out to everybody, and then someone hits a reply all. You don't want to reply all. You cannot reply all, especially with city business. If you do that, that's a violation of the Open Public Meetings Act. That's not something WCA covers, but that's something that we usually say, talk to your city attorney about and work with your city attorney on. But you have to be careful about string emails as well, where you start forwarding emails. And you then forward an email, and they forward that email. That's a string email. That could also reach enough people that could violate that OPMA, that Open Public Meetings Act. And that could subject the city to potential fines and penalties. Again, it's not a third-party court, but it is a fine and penalty that the city would have to pay on behalf of that. Be very careful about forwarding those emails and talking in group settings that aren't published, such as this study session. You can't go have a 6-person city council meeting, or not even meeting, at coffee, where you're now talking amongst each other. You can't do that now. You're elected officials. If 6 people are together, that's a potential quorum where action could be taking place, and you could be violating the OPMA because of your meeting. So be very cognizant about that fact. Next slide. Public Works. This comes up a lot. This is one of the big exposures in Washington State with political, what I like to call political engineering. Everyone in the neighborhood has a potential concern with a potential road. Maybe it's speed, maybe they want speed bumps, maybe they want stop signs, maybe they want a new intersection or some kind of traffic control device. So they come to council meeting and they say, please put up a stop sign, or please put up a crosswalk. Crosswalks are notorious for this. Crosswalks do not stop cars. They don't. Stop signs don't stop cars. People stop cars by hitting their brake, but sometimes they don't. But if you put in a traffic control device and you do so without proper what's called engineering warrants that justify it, you create a huge exposure if someone were to now get hurt. Because we rely upon engineers to defend the city for those traffic control devices, i.e. why they put a stop sign there, why they put a speed limit of 35 and not 55 on a road. That's all meets certain criteria. And if you start doing so because of political pressure, it's hard for us to defend. And in Washington State, we have what's called joint and several liability. Joint and several liability means if you have a third party that is fault-free, you have 2 or more people at fault for the injury, that person that was harmed could sue both people, okay? And they do. They sue everybody and anybody. But if you're found at least 1% at fault, you could pay the entire verdict. So what happens is, say you have a crosswalk, and someone wants a crosswalk mid-block to get to a park. And now Johnny gets hit in that crosswalk. Johnny's 5 years old or 8 years old. Johnny's fault-free. He's a kid. He did nothing wrong. Well, now they're going to sue the driver who hit Johnny and the city for putting in that crosswalk. If that crosswalk did not meet engineering criteria for installation, we can't defend the city for little Johnny's injuries. And who has the big dollar amount? The driver with $25,000 liability limits, or the city with $20 million in liability coverage? I can answer that one. It's the city with $20 million in liability coverage. That's where you're going to get dragged into that lawsuit. So we're going to need to talk to the traffic engineers, make sure that those crosswalks were done and meet those warrants. If it's done politically because you had a lot of political pressure from people in the audience or in the neighborhood wanting that crosswalk, that's not justification for it. And that's going to create a huge exposure for us as your carrier if that happens. So be very cognizant about those things and let the engineers engineer. That's what they're there for. If you have questions, you can always talk to them and say, hey, what can we do? But don't in open session say, oh my gosh, this road is dangerous or unsafe. That's an opinion. Your opinion will come back and haunt us in litigation. And again, we don't want to have to depose you and say, well, where did you go to engineering school to come up with said opinion? And we've done that. So again, it puts us in an adverse position, even with the elected official, especially if you're talking about lighting. And we talked to police about this as well with their police reports. Even when there's no one to prosecute criminally, you still want to collect facts and put those facts in reports, because those reports can be used not just for criminal matters, but also civil proceedings. So again, all those things can come into play. And it's very important that you don't put your opinion out there and say, oh my gosh, how many kids have to die before we do something? Well, that's not your role. Your role is to legislate and try to affect change through budgetary process. You can allocate money for certain projects, and there's discretionary immunity for your decisions. So you have discretionary immunity if you decide not to put a guardrail up because you don't have the money for that, and you decide to put that money towards sidewalk improvements or X, Y, or Z. You don't have unlimited funds. We recognize that, but you have to make those decisions in open session using the legislative process through the budgetary means. Then we can defend you for those actions or inactions. It's either an action or an omission. You should have done it. Why didn't you put a crosswalk there? Well, we didn't put a crosswalk there because X, Y, or Z, or we didn't have the resources to do so. And that's okay. You just want to prioritize and try and get to things when you can. That's your job as the legislative body, is to make those decisions as to where you allocate those resources through the budget. And again, I already said, avoid those promises or guarantees. Say, oh my gosh, don't worry, I'm so sorry, we'll take care of everything. Actual statements, but don't, because that's not your role. That will be our role as the claim handlers to kind of look at that and see whether or not there's negligence and liability on behalf of the city. Next slide. Executive session. This is a very important tool for council. This is your area to go in and have frank discussions about certain areas. It has to qualify that to meet an executive session criteria. We defer to your city attorney regarding that, but if it's a real estate transaction, if it's a personnel matter, collective bargaining agreements, any type of confidential information that needs to be discussed through closed doors, you can go into executive session. But what goes on in executive session, like Vegas, needs to stay in executive session. You should not be out in the public talking to your significant other, your spouse, your friends about what happens there. Because once it's leaked, you could even be waiving some attorney-client privilege information. So be very careful about that. And we say, talk to your city attorney regarding those issues, but this is a great tool for you. It's also, I've had situations where council members leaking information to the press about what happens in executive session. And it can only come from council, and we knew that. Well, that's your role then to let or sanction yourselves. You can pass sanctions against each other That is your right as a legislative body to call somebody out regarding that. And if it gets to too bad of a situation, maybe they'll be barred from further future executive sessions. Be very careful about that. You don't want to leak that information. It is a vital tool for you to have those frank discussions. Now, I'm not saying conduct business outside of the public view. No, it's only those areas that arise to those issues, such as like when you're buying or entering into contracts that you don't want third parties to know how much you're willing to pay for something. Obviously, this is public money. You want to try and get as good of a deal as possible. That's where you can go into executive session for. And next, final slide. Be mindful of written communications. Everything you do is a potential public record. You do not want to conduct business on your personal cell phone. I have two phones. One's my personal phone, one's my WCI phone. This is public. This is not. I do not want this to be public. This will turn public if I start conducting WCI business on it. Same thing with your own assets. Do not use your personal computer to conduct city business. If you're at home, do not use your personal computer. If you use your personal computer, that could be subject to discovery in a public records request. You don't want to have to turn over your hard drive to a judge and allow third parties to review it. Use your own or use your city-issued equipment. If you don't have that city-issued equipment, talk to staff or don't conduct business. Do not use your personal equipment for it. Same thing with Facebook. Be careful about social media, especially with public meetings where you can have that string again of contact and interactions, could violate the Open Public Meetings Act, and you don't want to conduct city business on social media platforms. That's not appropriate. And be careful about your role, whether you're acting as an individual or an elected official. Sometimes it's hard to delineate the two, and you sometimes can't. So you don't want to cross over on that. That comes up a lot with, I think, Nextdoor is a big social media platform. I know I had that when I was at the city of Auburn. And the city had their own official Facebook account, and that's fine. Then conduct business through that account. Do not, and be careful about finance laws and campaigning on social media platforms. And I would talk to your city attorney regarding that, because that could be very problematic as well. I know even on national levels, that's gotten a lot of people into trouble regarding how they conduct business on those platforms. And again, always use your city email. Don't use your personal email and direct things to your own personal account. So giving you a lot of information. Any questions for me?
I have a question.
Sure.
So you brought up the whole,
Mayor, could you use your mic?
oh, I'm sorry.
So you did bring up the whole Facebook page or the comments and stuff. So I have an issue with that right now, kind of. You know, I just kind of want to give it an example of certain council members replying to things on a resident page that's, you know, for the community. So what do you suggest happens in a situation like that?
It's tough to do, especially if, are you acting as an individual or as a council member? Just because you're an elected official doesn't mean you give up all your individual rights, but you don't want to be conducting city business or commenting about city business on Facebook or Facebook accounts. Once you start commenting, because you can't unelect yourself, you're an elected official. If you start commenting on other people as a city official about city business, that's where you can potentially get into trouble, especially if you're doing it on your own personal computers, because that's a public record. You can't, if someone requests that, you have to show metadata regarding it. So you have to be very careful about what you're saying and how you say it in what format, and whether you're acting as an individual or an elected official. And then if you're acting as an elected official, you're acting as an individual. You're not acting as a council as a whole. And once you start acting as an individual, that's when you lose your legislative immunity. You could be subject to personal litigation regarding that. So you're now outside of the council. You're acting as an individual council member, and that's what we try to avoid.
Anybody else have any questions? Mary? Over here?
Well, thank you for your time. I
Thank you
do
for
appreciate
coming.
the opportunity to speak with you tonight.
Thank
Oh,
you.
my pleasure.
So we're going to go ahead and move on to B, discussion of the energy. Sorry. Rob? To talk to.
Sylvia?
I'll go
He's
around.
come. Okay. We're going to go ahead and go on to B for the discussion of energy retrofits for public buildings, the solar energy grant, which is on the program contracts on page 19 to 40. You have any questions on that? Did y'all have time to read that? If you did, if you have any questions, feel free to ask. Okay, no, if there's no questions, we'll move on to D. Discussion of the disposal of the lumber. So this week, our tree started getting cut down last week. Gazelle Park is already complete. They're working on the south main park right now. And they have left the lumber for us. And we wanted to talk to the council about selling the lumber rather than disposing and giving it away for free. So I wanted to see what you all thought about that.
Well, if we sell it, if we do it, I mean, we don't have to.
Turn
sell
your
it.
thing on.
It is on.
Get closer.
If we can sell it, it would be nice, but we don't have to sell it at a enormous price.
Oh, no. And I think we looked into that and we kind of asked prices to the gentleman that was cutting the trees down. And he did give us some prices and what would be good, you know, for pricing.
Always coming over here and there's a white and red truck cutting the wood and taking it.
So we,
Had the officers go out and stop that, and I believe they did. Yeah. So we're gonna have the guys start moving that as soon as Monday.
Tuesday, man.
Yeah, Tuesday, I'm sorry. Monday's a holiday, but, so we're gonna have them start moving that. I know they're doing other things before the weekend. Andy, do you have any questions? Anything to say?
No.
Gary? Judy? Okay. So we're gonna go ahead and go on to we're going into executive session. So we're gonna go ahead and ask all the visitors to please step out for a little bit. We'll be on an executive session for 15 minutes. And so it's 6:46 right now, so we'll excuse the public.